Mr. Elkins a new trial, and it was time to try the case again, would we be forfeiting our right to the change of venue, and would we be forfeiting our right to this venue by consenting to the return of the case to Glynn County for non-jury matters? Is there any question under the law about that? What I'm going to ask the court to consider is giving us an opportunity to take a look at that.
Absolutely.
Perhaps this afternoon before responding.
Oh well, I think I can address that issue. Obviously, if you consent to move the case back to Glynn County for purposes of non-jury matters, which would be sentencing and appellate motion for new trial issues, I would think, and then of course he were granted a new trial either by this court or appellate court, then and we came back, then you would still have all your previous motions, would still be in effect, including the change of venue, unless you withdrew it or or something of that nature. So.
Well, Your Honor, we just want to make sure on the record that we wouldn't be waiving our right to this venue on retrial.
I don't think it's constitutional in this situation. Unless the state has any objection, I'm going to say that you're not waiving your right to a future change of venue in case of any proceeding. That's the court's interpretation right now. And so as long as I'm the judge on this, I mean, it seems that the state have any thoughts on that matter? No?
We would agree with the court on that.
Okay. Everybody seems to agree. So now you want to take a minute, have you talked with your client about this, having sentencing transfer back to Glynn County?
What we can do, Your Honor, is we can confer with him perhaps while you're proceeding on with the other portion of the case.
Okay. But I do want to get on the record before we leave here today.
Yes, Your Honor.
Because exceedingly important how we proceed.
Your Honor, I would agree.
Okay. All right. We'll be in recess for about, do y'all have a copy of do y'all plan on presenting further evidence?
No, we do have a certified copy of the count 13 with, and I'm not sure if Mr. McElvain's had an opportunity to look at it. He may have an issue. On the 1st of October 2008, it appears she was represented by
No, there's a sentencing
Karen
sheet.
Mead.
Sentencing sheet, but there's no entry of the plea and there's no arraignment. Arraignment cannot be waived. All the state has provided.
I believe arraignment is waived if it's not raised prior to entry of a guilty plea or the verdict of a jury.
There's no proof that the plea was entered.
But she has to have been represented by counsel and.
Karen Mead is returning.
There's a plea petition that the state has in their possession, but they do not possess any transcript of the proceedings.
Can I see the court see it?
Yes, sir.
Can we mark this as, for purposes of this, as State's Exhibit 1?
Yes.
So, I think I'm sure.
The court look at it.
Another issue, the jury wasn't sworn for this charge at the time as the case together.
That's what I mentioned earlier. I think we'd have to swear them.
Well, not only that, but they have to be sworn during the presentation of evidence. And the state has to recall the witnesses if they want to fit into this like that. Because they weren't sworn as to that charge at the time the evidence was taken.
the law allows them on this type of bifurcated proceeding to re-tender all the evidence that was submitted earlier. But I am concerned as to a plea petition is not the same as a guilty plea.
Your Honor, if you look at the last page of State's Exhibit 1, there's an order that has been entered by the court, signed by Judge Williams, and then an order that has been entered by the court, which is essentially the judgment and sentence of the court. I don't see what more documentation there can be that the court entered a judgment of guilt in the case and adjudicated it guilty and signed it, and the defendant was present. It was represented by counsel. I mean, I don't think you need to have a transcript of a plea to prove that there's an adjudication of guilt in a case.
No, I don't think you do either. I don't think you have to have a transcript, but where she actually entered signing the plea petition, we're missing part of the document here. We're missing where we're missing the portion that where she actually entered her plea of guilty.
Your Honor, the law, once I raised doubt as to the entry of the plea, the court requires the transcript. It can't just travel off of the plea petition itself. It has to see the plea colloquy that the Boykin rights were read and waived, that the client or the defendant entered the plea knowingly and voluntarily, and there just is no record of that in this case. Therefore, they can't.
You have a case that says that?
I have them in my file, but I wasn't ready to go. I thought we'd have a little break, but I can get that to you, Your Honor.
McElvain, may I be allowed to have a moment with my client to discuss the issue you referenced earlier?
Yes, y'all wish. Is there a place outside that they, okay. Y'all may be excused while we're.
May I see that exhibit again?
You may.
Your Honor, may I, while Mr. McElvain is looking at that, in the documents that we have presented as State's Exhibit 1, there is a plea petition in the case. And then there is an order of the court. The court read and considered the foregoing application, having examined defendant and defendant's counsel in open court concerning same, and it appearing that the allowing of such proposed plea is proper, the court having specifically advised defendants of his rights under Rule 33.8 of the Uniform Rules of the Superior Court, as said rights are set forth in the plea petition, and rights waiver form, the same petition being accepted by this court and entered as part of the official record, it is ordered and adjudged that such waivers are contained in this application, as well as such plea of guilty are freely and voluntarily, intentionally, and so forth entered by defendant. The defendant's entering the plea in the affidavit of counsel, there is a factual basis for the plea of guilty. And then this language, therefore it is further ordered and adjudged that such plea of guilty be allowed and accepted, and that such application in this order be filed and entered with such plea and made a part of the record in this case. Ordered and adjudged 1 October 2008, signed Amanda Williams, Judge Superior Courts, and signed by the defendant. Then there is on that page a final disposition. And it's count 1. It says the finding is signed by the then Chief Judge of the Judicial Circuit, and there was an order was entered in 2011.
Hereby waives the copy of the indictment and arraignment, and hereby changes their plea from guilty to not guilty. They sign that, showing that they've actually entered their guilty plea. You may be correct in the signing of a plea petition submission.
I mean, what more?
I'll ask you, want to take a recess for about 10 minutes, we're going to do a quick...
All right, does the court want to see this while it's making its, okay, you don't, well,
Your Honor.
I have an announcement on the record. Yes, Your Honor, we'd be willing to proceed with sentencing and appellate issues in Glenn County.
Your Honor, there's another matter. I understand there are a large number of reporters camped outside the front door of the courthouse. You have an unwritten gag order in effect. Now that the trial is concluded, I assume the gag order has expired.
Gag order has expired. Be careful, though.
Thank you, Your Honor.
Your Honor,
You may be excused. We have recess for about 5 to 10 minutes.
Your Honor, may I go to my car to get the...
Yes.
me too. Being around. We know that it's just professionals in theater and nothing.
I have my key card in the room. Okay, so I'm gonna send you. I will, okay.